I'm John Kane, and this is Resistance Radio. I want to thank you for listening. If you are catching us on WBAI in New York City or on WPFW in Washington, D.C., I ask that you support these two stations. Look, I'm not going to talk about Charlie Kirk or Jimmy Kimmel, but let me just say this. We're living in a time where voices are getting silenced. And we can talk about who's responsible for what, FCC, Donald Trump, ABC, whatever. We can talk about who's responsible. But there are pressures out there to silence voices. If you hear any voices on these stations that you think are important enough to keep hearing, you need to support these stations. So, well, I'm not going to talk about either one of those. You're hearing enough about those other issues on other channels, on other stations, on other platforms, and there are plenty of people weighing in. And I just wanted to say that if there's one takeaway from what you're seeing with shows being canceled and voices being silenced, we have the ability to keep our voices going. And I'm not saying that we're completely immune to the FCC, but we don't have the corporate overlords. We don't have political operatives that have that level of control over who says what on these stations. So, will that always be the case? Don't know. And are there things that work behind the scenes that many of us aren't completely aware of? Yes. But I know one way to keep this show, to keep Resistance Radio on WBAI and WPFW, is to support the stations and do it in the name of this radio station. Do it in the name of this radio program. So that's why I ask that you go to the website. I'm going to reiterate them as I usually do. If you go to buddy.wbai.org, you can become a buddy. You can become a sustaining member of WBAI and follow the prompts to do so. You can do as little as $5 a month. You can do as much as you want. But you can still do one-time donations, and you can still do timed donations if you've got money coming in at some point, and if now seems like the good time to log in, then by all means do so. That's what we ask of you. Or you can go and make the phone call, and the phone call is 1-833-922-4692. Or you can use letters, which might be a little easier for you to remember. That's 1-833-WBAI-NYC. And then you can follow the prompts. And look, if you do get an answering machine by chance, because perhaps multiple callers called in at the same time, just leave your name and your number, and somebody will get back to you immediately. Now, that's all for WBAI. If you're listening in Washington, D.C., then I ask that you go to their website, which is WPFWFM.org. Or you can call their numbers, which are 202-588-9739, or their 800 number, which is 1-800-222-9739. And it's the same thing. You can become a sustaining member there. They don't call them buddies, but you can become a sustaining member or do a one-time donation, time donation. And look, there are all kinds of programs. You can leave money in your will to these stations. There's any number of things you can do to assist these stations in staying on the air and to assist this program staying on the air. Now, I put this show up on Facebook. I put it up as a podcast. I put it up on YouTube. So if you're listening to this program by some other means other than the radio stations, I'm still asking you to support these radio stations. You make your choice. Support both of them. I mean, if you're in Washington and you want to support WAI, by all means. If you're in New York and you want to support WPFW, then by all means. I ask that you do both. And look, I know there are other affiliates that carry the station, and so if you're listening to this program on a radio station, internet or otherwise, please support the source of that of this program. Please support the source of the program. That's what I ask of you. All right. So, as many of you know, I was the executive producer on a film that we are just in the process of rolling out, and it's called The Long Hope. We are doing a screening of it this Saturday in New York City at the New School. It is a private screening. I do have the flyers posted and that kind of stuff if you want to reach out to the organizers to see if you can get on a list or whatever else. you know, we all have our list, and in fact, I've got my dear friend Reggie Johnson on that list. And whether he's available or not, these are the folks: Michael G. Haskin, Reggie Johnson. These are the folks that I hope will will join me for such an event, and along with others. So,
Yay, I'm on the list.
all right, and your dear wife too. So so there's some lists you don't want to be on. This is one it's probably good to be on. So we'll just leave it at that. um, so the gist of this film is to point out the slave era doctrines, legal doctrines that still exist today. Now, one of and look, the source of much of my information comes from people that you are very familiar with if you listen to this program over the years, and that's Stephen Newcomb and Peter Tirico. These are two guys that have done incredible work in exposing not just the doctrine of Christian discovery, but the legal doctrines that are spun off of that. And all of these come in the 1820s to the 1830s. Slave era legal doctrines, slave era sensibilities, all that stuff. And yet they still exist today. Now, one of the places that sometimes Newcomb and Tirico admonish me about is my use of the term racism. And part of their rationale, and I'm not going to speak for them, but part of their rationale is that by calling these doctrines racist, we are characterizing them in a way that diminishes what they're really about. I don't necessarily agree with that. And part of that whole thing is, we have a false sense of what racism really is. And I've done complete shows on the definition of racism before, and I'm going to talk a little bit about it today because racism is about power. Racism is about domination. It's about superiority and inferiority. It's about that dichotomy. It's about a specific group that is entitled, whether it's through their population, military might, wealth, whatever it is, that allows them to promote themselves as genetically superior based on their race. And then, of course, in many places, we're talking about white folks. Not all places, because look, if you're not the dominant culture, in China, I suspect that Chinese may be guilty of racism. I don't know for sure, but I think it's entirely possible. Because if you can not only assert that power, but then rig the game, because racism is systemic. Racism is where you build into the process. So you look at the U.S. Constitution. The U.S. Constitution, I'm sorry, folks, I know many of you are really patriotic, but it's a racist document. I mean, look, it counted black people as 3/5 of a human being. I mean, and not 3/5 of a citizen either, even, but 3/5 of a body that they could count up so they could have more power in Congress. That's what the enumeration clause of the U.S. Constitution was all about. And of course, Native people, we're not counted at all. I'm okay with that because the whole position that I've maintained through my entire life is that we aren't a part of that system. And there have been policies, legal doctrines, and laws written that presuppose that we have been subjugated, even though there's no legal basis for that. That's what the film is about. And so I call these the doctrine of Christian discovery, the plenary powers doctrine, and the trust doctrine. I call them racist. And I oftentimes, whether I'm talking about the mascot issue or I'm talking about these issues, what I try to highlight is the unique racism that Native people experience. Because I'm not trying to paint a broad brush about racism. Now, and let me say this right off the bat. I don't believe in the concept or the construct of race. I don't. I don't believe that there is enough genetic difference between people simply because of the curl of their hair, the color of their eyes, or their skin, or any of that. I don't believe there's enough genetic difference to make an assumption about where somebody is on the intellectual ladder, or any other way to gauge superiority or inferiority. I don't believe that's true. I think that I just think that whole thing is really based about creating a construct that is initially born out of Christian superiority. So we're talking about the domination of Christianity in Europe and what they did to their own people as a result of it. Because look, not everybody in Europe, Christianity it doesn't come from Europe. So when it sweeps into Europe, there are a lot of people who had their own ideological beliefs, spiritual beliefs, if you will, their religious beliefs, if you will, that all of them were destroyed by those who were touting Christianity as the right religion, the one and only legitimate pathway to God and heaven and all that other stuff. And if we know, and look, there are still people, and not just people who recently died, but there are still many people to this day. Now, and I'll argue till the end that this notion that one characteristic of skin color or national origin or religious belief, ethnicity, I don't think there's any of that stuff that can legitimately characterize one people as superior or over another. So having said that, I reject the notion and the construct of race. But racism is real because racism is behavior. It's not scientific like some would argue. That people will try to argue that race is a scientific fact. No, it isn't. It isn't. But racism is. And when I talk about racism being systemic, by that we mean that the people with the power to create policy, law, governance, social structures, rig the game so they keep that power. And and we can get into conversations about redlining, and we can get into conversations about Jim Crow, and we can get into but here's the thing. The reason I did this film, and I wrote the most of the film as well. The reason I did this film is because people don't understand. They can't fathom the idea that a country that touts all of this rule of law and truth, justice, and the American way, equality, all that stuff that they say in their anthems and in their pledges and in their rhetoric associated with their declarations of independence and constitutions and all that stuff. It's not true. Most of it is still all tailored towards one group of people, white folks. And wealthy white folks, let me clear that up, I'm sorry. White men, to be clear. White men. That's what it was all geared towards. So when I bring up the fact that there were these slave era legal doctrines, look, it kind of makes sense that it would develop in the 1820s and the 1830s because, look, chattel slavery was the biggest industry in the United States at that point. Yeah, we can talk about, well, yeah, wasn't the product that slavery produced the biggest industry? No. The biggest assets, the most valuable assets that existed in the United States in that era, in that 1820s to 1830s, right up to the 1850s and 60s, was slavery. If you had a legion of enslaved human beings to do your work, and you could do as little as humanly possible, as little life-sustaining give back to them as possible to get their labor out of them. And here's the thing. For those who don't recall, Thomas Jefferson was actually considered the ultimate in as far as slavers go. He did the math. He did the calculations. He knew at what point when you deprive a human being that you have in bondage of certain necessities, whether it's sleep, rest, nutrition, he knew when the labor drop off and those graphs intersected, said, okay, I've got to do this much if I want to maximize my profitability out of slavery. And he did the math, and there have been recent revelations at how painstaking his calculations were to make sure that he can maximize this. Now, this is Thomas Jefferson. Not only is he the author of the Declaration of Independence, but he's actually considered one of the more enlightened of the founding fathers of the United States. And that just lends to the absurdity of who is who and who's heroized and whose heroes are whose. So while I don't disagree with Stephen Newcomb or Peter DeRico on any of the factual stuff that they, and they are still. I'm going to talk about something that they brought to my attention recently. They do a Substack and they do a podcast, and if you want to look up, the work of Stephen Newcomb and Peter D'Erico, especially when they work together, these guys are phenomenal. I mean, they're two books, Pagans in the Promised Land by Stephen Newcomb and A Federal Anti-Indian Law by Peter D'Erico. These are like, I hate to use words like Bible, but these are my go-to books. These are what my film is primarily based upon, and I do a full acknowledgement of that at the end of the film. So I can't express enough how much the work of Peter D'Erico, not just the work of that they did in the past, but the work that they're still doing every day. And I'm going to talk about something they just brought to my attention. And they didn't call me up and say, "Hey, John, you got to know this." No, they put it out for the world. They put this stuff out there in their podcast, in their Substack writing, in all the stuff for everybody to know. These guys are not holding back. They are not taking knowledge to the grave with them, as some sort of pillow to rest their head on to say, gee, wasn't I smart? No, they're sharing it every step along the way. And I want people to be aware of that. But on the one area that we do have a little bit of a difference of opinion is, I have no problem characterizing these policies, the laws built on these legal doctrines and the legal doctrines themselves as overtly racist and uniquely racist to Native people. And one of the examples I can always cite is, we know about about Brown versus the Board of Education. I think it was 1955 or something along those lines. I don't have the date in front of me. But so this is at a time when the Cold War is raging. And I've learned a lot of this, again, directly from Peter D'Erico. This is when the Cold War is really raging. And Russia is looking for any weakness in the American system. And clearly, there were plenty to look towards, but there was none more pronounced than the racism of the United States. I mean, the whole Jim Crow era, and sure, slavery was now gone, but what black people were experiencing was hell on earth. And there's no other way to describe it. So, and that wrestling, that balancing act that the United States was trying to do by saying, well, now that we've made black people citizens and we've abolished slavery, and we've got to figure out how do we manage the equal application of laws, and of course they come up with this with segregation and separate but equal. And Brown versus the Board of Education addressed the racism in how children are being educated, the disparity between black children and white children. So here you have a Supreme Court, that takes on the issue of racism. And part of it, again, let me, I just mentioned this, but I want to put a little more emphasis on it. Russia was beating the crap out of the United States over the overt racism. They were winning the PR war over the racism. And it's not to suggest that Russia didn't have its own issues, but they hadn't built their entire economy on black chattel slavery. So, Russia could make these claims, but and we can get into where their persecution and discrimination and prejudice were on other issues. But they were beating the crap out of the United States over this. So this Supreme Court makes their ruling, and they flat out address the racism that is in that whole separate but equal policy of education, and they say that it's illegal. So they make a ruling. They make a historic ruling. Because this is really the foundation that leads to civil rights movement and changes and all that other stuff. So this was a historic ruling by the Supreme Court. But that same Supreme Court, a year later, the same makeup, the same exact judges, did a ruling against the Tlingit in a case called Teton versus the United States, where the Teton were trying to sue the United States because they were taking their resources. They were literally harvesting logs, millions of dollars worth of logs off of their land. And they said, look, you can't just take this stuff. And if you do, we deserve compensation. And that same Supreme Court that could address racism, when it came to the education of children, had no problem calling upon the most racist legal doctrines in that are part of U.S. jurisprudence, and they flat out said that the Native people only had the right of occupancy, and that right of occupancy could be exterminated without compensation. So, and this all goes back to the doctrine of Christian discovery. And for those who are not familiar, I'll just briefly explain that the doctrine of Christian discovery was this legal doctrine codified in 1823 into U.S. law that basically said the United States could claim title to the land based on discovery. Well, what kind of discovery? Well, based on Christian discovery. Now, the United States didn't discover anything, but the European countries that did, they could sell what they called that discovery title. And so it exchanges, it goes, Spain's involved, France is involved, and that is how the United States claims title to the lands of that they claim as part of the the United States. They claim it based on their Christian origins being handed down from European country to the colonies and then to the United States, that they would somehow be able to claim title based on this doctrine of Christian discovery. Now, again, I know some of you are saying, yeah, but what about the separation of church and state? No, there was none. Not as far as this was concerned us. This was clearly church dogma. By the way, the church now claims that that wasn't the case. The church now has repudiated. They haven't rescinded it because the church now claims, and this is the Catholic Church, which that's all there was at the time, right? The Catholic Church says, oh, we never meant to create that. That was the monarchies, the Christian monarchs of Europe that misinterpreted papal bulls. No, there was no misinterpretation. There was no misinterpretation. But the church tried to blame it on the monarchs. And they said, no, we reject. Now, the church did offer papal bulls after the initial papal bulls that essentially established the doctrine of Christian discovery by claiming that the church now rejected the notion that non-Christians could be enslaved. They went to that level to say, well, even if they're pagans, we have to acknowledge that they are human beings and they do have souls, and that's why we got to work like hell to convert them. So, I mean, that was kind of the policy of the church. Now, it didn't change. It didn't end any of the enslavement of people, native people or people from Africa. Because even that papal bull comes in the 1500s. Chattel slavery hadn't even reached its peak yet. So that papal bull was ignored, while the ones that established the doctrine of Christian discovery not only become rule of law, they got codified into every part of property law throughout Europe and Africa and, of course, the Western Hemisphere. So, but again, I know this sounds like ancient stuff, right? It sounds like, yeah, but that's a long time ago. Well, I've always brought it up. And in fact, I've done videos and I've done shows about the fact that Ruth Bader Ginsburg, a Jewish lady of all things, cited the doctrine of Christian discovery not only in her footnotes, but it's part of her ruling. I mean, she didn't just put it in her footnotes. It is the driving principle of her ruling against the Oneidas. When the Oneidas were not just occupying or taking land, they were actually purchasing land in their ancestral areas, in an area that the Supreme Court already ruled that they had the right to sue for title for. So rather than suing for title, they just bought it. They just bought the land. But then a small municipality called the City of Sherrill decided, well, we're not going to allow them to take that land off the tax rolls. And Ruth Bader Ginsburg agreed. In fact, the majority of the Supreme Court, it wasn't unanimous, I don't think, but the majority of the Supreme Court agreed that the Oneidas could not reclaim lost land. Ruth Bader Ginsburg, she even cited something she called the doctrine of impossibility. She claimed that once you lost jurisdictional control of lands, even if it was through sinister, or underhanded nefarious means, even if it was stolen, even if you have a right to claim that land, that doesn't mean you can necessarily reassert your sovereign control over the land, which the United States has a big problem with anyway. So and she even kind of in a way rubbed our face in some of our own culture. We have a when we talk about death, we refer to our logs and our embers being scattered in our family, in our nation, or whatever else. And that the healing process involves gathering those logs and gathering those embers and reigniting our fire, our family fire, our community fire, our nation fire, our confederacy fire. That's what we refer. And she, in her ruling, said the embers of they that the Oneidas could not reignite the embers of their sovereignty that had long grown cold. So she even kind of rubbed her face in a cultural reference. Again, Jewish lady considered the liberal darling of the court makes this ruling against the Oneidas using the doctrine of Christian discovery. Now, I will say that the doctrine of discovery was all about the doctrine of Christian discovery. And in the initial law or the initial ruling where becomes codified in U.S. law, it's called Johnson v. McIntosh. The Chief Justice, the longest serving Chief Justice of the Supreme Court in the history of the United States, Chief Justice John Marshall, he made it very clear about the Christian nature of this of the doctrine of discovery. This was about Christian people laying their eyes on a people and on a lands and then being able to claim them. He even went so far to say that they could equate conquest with discovery. So he even suggested that the mere laying of Christian eyes upon us as a people could constitute conquest of our people. So anytime I hear somebody say, "Yeah, but you're a conquered people," no, we're just the people who your eyes laid upon, and then you equated that with conquest. That's just Chief Justice John Marshall, and this is a part of U.S. law. So Ruth Bader Ginsburg, she cites in 2005. I mean, 2005. We're talking about 20 years ago. But I know some people are saying, yeah, but that was 20 years ago. And didn't she kind of recant some of that? Yeah, in her book that she sold and made money off of. She didn't overturn her ruling. She never entertained the idea of the Supreme Court revisiting some of this doctrine of discovery, Johnson v. McIntosh, or any of this stuff. No, she never went there. But she did say in her book that she thinks that was a wrong ruling. Well, thank you for that. I mean, that's all that meant for her is that she got to absolve herself and make a little bit of money on it at the same time. I know some of you people are thinking, yeah, but that's the notorious RBG. She was our hero. Well, she can be your hero all you want. She's not ours. But here's the thing. And again, I owe this to Stephen Newcomb and Peter Dorico. 3 weeks ago, I'll give you the exact date. It was filed on August 21st, last month, August 21st. A 3-judge panel hearing an appeal cited Johnson v. McIntosh and the discovery doctrine. 3 weeks, not quite 4 weeks ago, almost 4 weeks ago. It got cited again. 4 weeks ago. Not 20 years ago, not 50 years ago, not 100 years ago, not 1823 when Johnson v. McIntosh was ruled upon. So in all that time, slavery ends. The 14th Amendment comes in. The Civil Rights Act passes. Brown versus Board of Education. But nothing has changed for us. They actually built upon the doctrine of Christian discovery by claiming that we were wards of the federal government. There's no legal basis for claiming that. There's no legal basis for them to even claim that we are in any way a part of the United States, other than the fact that we share some land. Because even the doctrine of Christian discovery it's not legal. And I say it's not legal for a couple of reasons. Part of it is that this ruling comes in 1823. There had already been treaties that were entered into, drafted by the United States, that recognized our titles to our lands. Yeah, 1794, the Canandaigua Treaty, 3 times says the United States acknowledges that the land is ours and will never claim the same, nor will they disturb us in the free use and enjoyment of that land. 3 times it says it in the one treaty. Now, we didn't write that up. And it's not the only one. And it's not the only one that would say things like that after 1823 in Johnson v. McIntosh. But what happens is this stuff gets put into a box that they always go back to. And then they'll keep calling it settled law. So I'm going to read a little bit of what was written or what was filed in the courts just less than 4 weeks ago. The national policy governing management of Indian lands. Now, why would there be a national policy of the United States governing our lands? Governing management of our lands. That all by itself is a bit problematic. They said it has vacillated throughout history. No, it hasn't. Every time your court takes a look at this stuff, you guys cite the same thing. There's no vacillation. The only thing that, if you want to call it vacillation, I call it not using vacillation, but using Vaseline to make it go down or make it hurt a little less, I guess. You take the word Christian out of it now. You barely mention the word Christian when you mention the word discovery. So, I mean, that's not vacillation. That's euphemism. That's use of euphemisms to deceive and to, occlude the truth. So anyway, at our founding, the United States asserted title to these lands, and then it says, see Johnson v. McIntosh specifically, and it says the ultimate absolute title of quote unquote Indian lands has been considered acquired by the United States by discovery. So where is this in the ruling? You must have to really dig for this to find this in the ruling. No, this is the first item in the ruling. This is under number one, background, Indian lands. So they don't even waste any time. It's not buried in some sort of obscure legal dicta. They put it right in the beginning, right at the top. It's the first thing they cite. And they cite it as settled law. And they say, at our founding. But again, no, it wasn't at your founding. This was 1823. You claim to have been founded in 1776. Your Constitution comes, a couple of decades after that. But it's still decades before this. There is no place in any of those founding documents that suggests the United States owned all of our lands. It doesn't become a legal remedy until 1823. That's not at your founding. That's decades later. Almost half a century later. Now, I'm not saying it wasn't always the intent of the founding fathers, but there's no record of that. There's no record of anything in either of their Articles of Confederation or the U.S. Constitution that characterizes us or our lands as part of U.S. conquest. That language doesn't exist. There's nothing that says that we were subjugated as a people. In fact, it says just the opposite. It treats us in the same manner as foreign nations, both for treaty making and for the regulation of commerce. Commerce Clause says Congress shall have the power to regulate commerce in and among several states with foreign nations and with Indian tribes. It doesn't say of, and it only says that. Yet based on that one line comes this notion that we are somehow subservient to the United States. A complete contortion and misinterpretation of that line. And it's conservative justices that question it. It's guys like Clarence Thomas and Sam Alito that wonder, wait a minute, I don't see where this trust doctrine is really legal, or that there is even a legal trust between us. It just seems like a strategy to assert power. That's what Sam Alito said. That the whole trust relationship was about controlling us. It wasn't about taking care of us. So when my own people say the United States has a trust responsibility, I say, oh, hell no. They don't. They're not our trustees. And of course, they go a step farther and say that their Congress, by virtue of that same clause I just read in the Commerce Clause, has absolute and exclusive power over us. not only does Congress have that exclusive power, which means nobody else can question it, not the executive, not the courts, nobody. It's one of these situations where the legislative branch has no checks and balances. In fact, again, that was Sam Alito asked that same question. I don't see where there's any limit to the power then. If Congress has plenary powers, which means absolute, I don't see any evidence that there's any limit to that power. It's certainly not the courts. The courts keep accepting this plenary powers doctrine as settled law that can withstand any challenges. That's what the Brackeens, when they tried to challenge the Indian Child Welfare Act, the court said, well, we got to recognize the plenary powers of Congress. So we don't have to hear whether the Indian Child Welfare Act is discriminatory, whether it's unjust, whether it's based on racism or any of that stuff. We don't have to consider any of that. Or is it abuse of federal powers over states' rights? No, we don't have to consider any of that because we have accepted as settled law that Congress has been granted through the U.S. Constitution, which it hasn't, ultimate and plenary powers over the affairs of Native people, the lives, resources, and apparently our children as well. That Congress has that power. So no, I don't care how much oil money you have, Brackeens, you can't challenge that because we're considering that settled law. 2 Supreme Court justices didn't rule with the majority, Clarence Thomas and Sam Alito. And part of the reason they didn't, their arguments are always against this legal authority that has been, again, acknowledged or bestowed upon Congress. They said, no, we don't find it constitutional. So that's the reason I talk about this power. And again, I agree with Peter Dorico and Stephen Newcomb entirely that this is absolutely about domination. And it's domination perhaps not because they viewed us as racially inferior. That's a part of the domination. They created these laws so they could assert superiority over us. I mean, they've often, throughout U.S. history, talked about us being primitive, unsophisticated, ignorant. The whole idea of casting us as wards of the federal government made it sound like even though we had existed for tens of thousands of years and had thriving lives and economies and social structures, that somehow once white people showed up, we became incompetent. All those Osage who were millionaires because of oil being discovered on their lands, they were deemed incompetent. In fact, they had to register each month to some federal official and declare, yes, I'm incompetent. They had to literally say those words to have their money made indirectly available to them through their guardian, a white man, because they were too incompetent. They passed the Indian Gaming Regulatory Act because they thought that we were too untrustworthy and too incompetent to entertain gaming on our territories. They thought, they claimed that, it was to protect us from organized crime. Well, that's what the states are. We got extorted for $500 million by Kathy Hochul. There was nobody protecting us from that organized criminal activity. Oh, by the way, what did she do with that money? She gave it to her billionaire buddy who owns the Buffalo Bills to build a new stadium. Yeah, you can't make this stuff up. You just can't make this stuff up. So I'm not arguing against Stephen Newcomb and Peter Dorico. I agree wholeheartedly with their positions on all this stuff. They do have, sometimes, like I said, they do have a tendency to admonish me about using the word racism. But look, I think people have to understand what racism means. Racism is about rigging the game. And there is nothing that is more evident and more specific about rigging the game than the doctrine of Christian discovery. It only impacted Native people, at least in the United States and Canada. It only impacted indigenous people. The trust doctrine, somehow subjugating us as incompetents in our own world that we had been a part of since time immemorial, saying that we were somehow incompetent to take care of ourselves. And then in that process, not only delegating us as wards, but delegating themselves as our trustees. I mean, a legal trust has three components to it. It has to have somebody with the power to create the trust, somebody who can make a legal case that somebody needs to be protected in a trust, and then somebody who can appoint a trustee to make sure that those beneficiaries or wards are the primary beneficiary. None of that stuff exists in the United States in their so-called trust relationship. And of course, the plenary powers doctrine, which is just, I mean, the idea that, I mean, we live in a time now where people are saying, well, the executive seems to have unchecked power. Well, as far as Native concerned, that's what Congress has had since, well, they didn't actually codify it in law specifically until 1871 when they included it in the Appropriations Act of 1871. But it was already being counted upon since the 1830s when this notion of plenary powers was being fashioned by, again, Chief Justice John Marshall. So I think, so you hear this stuff and you read this stuff, and you understand that these judges, and there's three of them that ruled in this thing unanimously, they acknowledge that Congress passed the Indian Allotment Act in 1877, also known as the Dawes Act, which sought to extinguish tribal sovereignty. Well, how could they do that? What was the legal authority to do that? Well, in 1870, they were already saying that Congress could do whatever it wanted to do. So that's how they could do this. One goal of the allotment policy was to assimilate Indians into Anglo-American culture. So again, this is what Congress was trying to do. They were trying to exterminate us through assimilation. Another was to open Indian lands to white settlement, so to steal our lands. I mean, these are the judges that are acknowledging this stuff, and it's a part of the ruling. Now, what was the ruling? Well, the ruling was really about a guy who was trying to sue the federal government to do its job. And that job was supposed to be to sort out the mess that they made over land titles through the Allotment Act and everything else. And what the courts were ruling, and what this court also ruled, was that sovereign immunity protected the United States from lawsuit. So they could not be sued to do their job. Now, where does this become absurd? Well, I'll tell you one of the places is because one of the reasons the United States rejected the UN Declaration on the Rights of Indigenous Peoples, and there were a couple of reasons. The primary reason they rejected it was because they didn't like the idea that it was asserting self-determination among Native people in the international definition of that. Because what the United States wanted to do was promote, and this is what they consider their current policy, self-determination, promote limited local self-determination. So in other words, we're not going to recognize Native people as having the true attributes of sovereignty. We're going to let them govern themselves a little bit. They can run their own organization. And in fact, they only look at us as organizations. They look at it as us individually, as not as citizens of distinct nations. And I'm not saying I'm not crazy about that definition anyway, but they look at us as members. We're merely members of a tribal organization that has certain governing characteristics where the United States gets to determine the metes and bounds of that sovereignty. But they specifically draw that limit on us exercising sovereignty over our lands and over our resources. That's what the United States was. That's why they were directly opposed to the UN Declaration on the Rights of Indigenous Peoples. But they also, and in this part, I was at a meeting with all of the federal agencies up on the stage at the museum in Washington to have this open conversation. This was during the Obama administration. And what they kept talking about, their concern about this UN declaration, this UN DRIP as it was called, the Declaration of the Rights of Indigenous Peoples, that it would somehow undermine the current remedy. They kept saying the current remedy for conflicts with between the United States and Native people. So I asked them, what is this current remedy you keep talking about? And they said, well, our court system. Your court system created these illegal legal doctrines. The doctrines, they're the ones who put those into U.S. law. The doctrine of Christian discovery, the trust doctrine, and the plenary powers doctrine. And your courts will reject when we try to force your government to do what it's supposed to do, what it's mandated to do under all all kinds of agreements, not just treaties, but even under their own constitution. So your courts are not the remedy for us. It's not even available to us. For the most part, we couldn't even use your courts for over a century. We were not considered worthy of being a party to bring an action in court. We had no standing in your system to bring any kind of legal action. So when I hear politicians or department heads suggest, yeah, well, our concern with the UN DRIP was that it was going to undermine our current remedy. And their current remedy are the very courts that created these racist legal doctrines. And yes, racist to the point of creating absolute authoritarian rule by the United States over our lives, over our lands, and over every aspect of our future. That's what, and your courts time and time again keep calling this settled law. It's not settled law. Not just because two of your Supreme Court justices are questioning it, because we are questioning it. So this is why we produced this film, The Long Hope. We produced it so that people would understand that you've been lied to. There was one other point I wanted to bring up. It said, in the 19th century, through treaties, the federal government sought out to confine tribes to reservations. It wasn't through treaties that our people ever agreed to be confined on a reservation. It was through aggression. It was through massacres. It was through torture, the murdering of men, women, and children. The treaties that they claim that these judges in this ruling just 3 weeks ago, the treaties, all they did was, that was like a surrender agreement. Yeah, you can call a surrender a treaty. But when you talk about treaties, you're talking about, I mean, the idea or the concept of a treaty is that you have equal parties. You have parties that are looking for a resolution that is equitable to both sides. That's not what these were. So you have judges, and you have judges today that embrace these racist legal doctrines, the racist authoritarian rule of the federal government today, not from 1820s and the 1830s. So that's why I do the show. People talk about free speech and about constitutional rights and that kind of stuff. I'm not fighting. I'm not looking for you for any of that. I'm not looking to your Constitution. I don't want constitutional protections. Now, I'm not saying they can necessarily be denied us because we're here. I know that, and I'm not playing that as a double standard here. But so as I sit here and say that I'm not a U.S. citizen and that I'm critical of the United States, are we reaching a point where that becomes dangerous to me? I don't know. It's not going to silence me. ABC is not going to silence me. Paramount, no. The FCC, because I'll do this as a podcast if for whatever reason WBAI or WPFW get under attack. If they get attacked for the content, for me speaking the truth, and I'm not even offering opinion here. The case is called Halverson. It's Halverson versus Burgum. Burgum is the Interior Secretary. So this is James Halverson. That's Halverson versus Doug Burgum, the Secretary of the Interior. Read it for yourself, folks. I mean, you don't even have to read very far. There's a summary in the beginning, but then it starts up with its first real segment of the ruling is called the background, and it's titled Indian Lands. You don't have to read very far, and like with many of these things that deeply codify or continue to codify or create again a pattern of settled law, as they say, the ruling is almost irrelevant. I mean, the fact the United States is claiming sovereign immunity from being forced to do their jobs, yeah, that's not even my biggest concern. My biggest concern is that a mere month ago, federal judges, and I don't care who they're appointed by, because they all embrace it, whether it was Ruth Bader Ginsburg or any of the liberal justices, Sotomayor, Kagan, Jackson. None of them have bothered to read enough into these racist legal doctrines to say, wait a second, we got a problem here. Now, the only two who are raising any concerns about it right now seem to be, of all people, Clarence Thomas and Sam Alito. And you know what? They aren't raising it because they want to fix it for us. They just see that there's a problem. They just see that as strict constructionalists of the U.S. Constitution, which is, again, a racist document all by itself, they're saying, yeah, we've made some assumptions here that aren't quite right. Now, I don't know if they'll ever swing any more conservative justices, but if you've embraced this nanny state notion so much like the left has, including the liberal justices of the court, and you're so concerned that the bottom will drop out of our existence if we're not considered wards of the federal government, well, I got to tell you, I have no desire to be a ward of the federal government. I'll take my chances on my own. I want a free and independent existence. That's my desire. My desire is sovereignty. It isn't constitutional rights. It isn't civil rights, because that's all tied to the Constitution as well. It's rights as a human being. So human rights, I want freedom. You look, when slavery ended, the black people who had been enslaved were not ever granted freedom. They were granted citizenship. That's not freedom. Freedom to choose what you wanted to be was one thing. But just like when they tried to do it to us in 1924, they simply declared it. I reject it. I reject the notion of having citizenship forced upon me. And you know what? All of many Native peoples did. We all had a tendency to, at first glance, say, oh, hell no, you can't do that to us. Many of us didn't even know about it until draft notices started showing up during World War II. We said, you can't draft us. We're not yours. Even though Native people, for whatever reason that I'll never fully understand, enlisted at a very high rate. Part of it is because I think they thought as a soldier they would really have equality. I'm not looking for equality. I'm looking for freedom. I want to thank you for listening. I'm John Kane, and this is Resistance Radio. Yahweh.